Assalamualaikum and good evening, Dr. Hana. Today we from Group 3 will record our activity 2 online court. Our case is Majlis Amanah Rakyat MARA versus Datuk Abdul Rahim bin Abdul Halim and own recognition. Okay, my name is Nurul Afiqah binti Shamsir. My metric number is 201251. I as bailiff.
Hello everyone, I am Amar Ben Latif. My metric number is 19998. In this role play, I'll be playing the role of the judge.
Assalamualaikum. My name is Farifazana Abdul Salam and my metric number 202502. I play a role as plaintiff 1.
Assalamualaikum. My name is Nur Najah binti Hussein. My metric number is 201320. I will be plaintiff 2.
Assalamualaikum. My name is Nur Amalina. My metric number 201182. I play as defendant 1.
Hello everyone, my name is Gagas Angsa Prabowo. My metric number is 01416. I will play as defendant 2.
All rise. The court is now in session. The judge is presiding now. Please be seated.
Good morning, ladies and gentlemen. The court is now calling the case of Majlis Amanah Rakyat MARA versus Dato Abdul Rahim bin Abdul Halim. Are both sides ready?
Ready for the people, Your Honor.
Ready for defense, Your Honor.
May I proceed the issue, Your Honor?
Yes, you may please proceed.
Thank you, Your Honor. I am the senior counsel acting on behalf of plaintiff in this proceeding together with my co-counsel. On 12 March 2018, MARA issued a requisition notice to Mac Bhumikar's board of directors to convene an extraordinary general meeting for the purpose of passing two ordinary resolutions, which were first, to accept the UMW offer at a purchase consideration of 2.46 ringgit Malaysia per share for Resolution 1 and for Resolution 2. And second, to appoint Muhammad Saki bin Jalil and Wong Fei Li to Medbukar's board of directors. As a result, plaintiff respectfully submits that the issuing of the requisition notice has satisfied the shareholding criterion set forth in the Articles of Association and Section 311 of the Companies Act 2016, namely, that at least 10% of the shareholding has been satisfied.
May I proceed with the next issue, Your Honor?
Yes, you may please proceed.
Whether rejection of requisition notice a breach of duty by director has complied with the Article of Association under Company Act 2060, Section 311. Unfortunately, the requisition notice by MARA was rejected by the first to fourth defendant during the Board of Directors meeting on 26th of March 2018. The plaintiff submit that the rejection of the requisition notice was breached by the first to fourth defendant of the duty under the article and section 311 of the Company Act 2016. That's all, Your Honor. Thank you.
All right, is the defendant ready for the case?
Your Honor. Yes, we are ready.
You may please start now.
Thank you, Your Honor. I am the senior counsel acting on behalf of the defendant. In this proceeding, together with my co-counsel, the defendant claims that on 26 March 2018, in the minutes of the board of meeting, revealed the requisition notice was defective. As resolution, one had to be passed by the method of special resolution, whereas the requisition notice had referred to a mere ordinary resolution according to Article 75 of the AOA.
Next, for the issue of whether the rejection of the requisition notice a breach of duties by director has complied with the Articles of Association under Company Act 2016, Section 311. The defendant declared that the pursuant to Section 211 of the Companies Act 2016 and Article 118 of Medbumikar Marasnian Berhad, Article of Association. The management and control the business and affairs of Medbumikar Marasnian Berhad lies within the exclusive purview of its board of directors, and therefore the said board has unfettered discretion to reject the offer, date 7 March 2018 by UMW Holding Berhad. That's all, Your Honor.
Plaintiff 1, are you ready with your arguments? If yes, please proceed.
Yes, thank you, Your Honor. After the rejection of its requisition notice by the board, on 12 April 2018, MARA issued the notice of EGM to convene an EGM on 30 April 2018 to table Resolution 1 and Resolution 2, which is EGM notice. MARA convened an EGM pursuant to the EGM notice and passed the resolutions. Meanwhile, the defendant circulated a director's circular resolution to appoint the fifth and sixth defendant to Medbumikar's board of directors without MARA's representative and received a signed director's circular resolution on 12 April 2018. It shows that the action of the defendant was a breach of duties of the directors.
Objection, Your Honor. Excuse me, Your Honor. I would like to object.
All right, you may.
I cannot agree with that submission of MARA, whether it is by an inadvertent omission to amend Article 137 or whatever the wording of Article 137 merely says that Director Circular Resolution DCR has to be signed by a majority of the directors of the company and does not stipulate that one of them must be the MARA representative. That's all for me. Thank you, Your Honor.
Okay, the court will now take a recess of 10 minutes to allow the jury to reach the final decision.
Court is back in session.
Thank you, Defendant 1. Now, the court will give its judgment. After listening to both closing statements, the court has reached the judgment for this case. Since the right to make recommendations is not provided and the resolution is not a special resolution with 75% majority, the recommendation of the shareholders will not be binding on the board, but the board must still consider it and act in the best interest of the company. It is incorrect to state that the directors have unrestricted discretion to reject UMWH's offer. The board can only reject an offer if it is in the best interest of the company. Since I have held that the appointment of the fifth and sixth defendants is invalid, I am unable to grant an order in terms of the remaining priors in the counterclaim. However, in order to make it clear that Resolution 1 is only a recommendation to the Board of Directors and is not to compel the directors to act in a certain manner, the court declares that Resolution 1 is valid only in so far as it is recommendation to the board and not a directive to the board. Otherwise, the court dismisses the other priors in the counterclaim. I order cost of 20,000 ringgits to MARA payable by the first to sixth defendants jointly and severally, and cost of 10,000 ringgits each to the eighth defendant and the ninth defendant to be paid by Medbhumika. All costs are subject to the allocator. I was concerned about the first to seventh defendant's claim that accepting the UMW offer would put Met Homika in breach of various agreements and not in the company's best interests. However, there is no resolution or recommendation of any binding nature made to the board in relation to the UMW offer. I am of the view that such concerns do not impact the relief to be granted by me. The board will have to deal with the UMW offer in the best interest of the company under the law. Thus, the originating summons was allowed and the counterclaim dismissed. That's all. Court adjourned.